All right, we'll move on to the third session of our mood competition. All the best, participants.
The Supreme Court of Tanve is now in session in the matter of Connect Private Limited versus the Democratic Republic of Tanve. The court will now take appearances. Senior counsel appellants and senior counsel respondent, introduce yourself.
May it please the Honorable Court, Your Excellency, my name is Sevita and I appear here with my learned junior Vidya, representing the appellants Connect Private Limited and a group of digital right activists.
May it please the Court, Your Honor. My Excellency, my name is Hanna Venkatesh. I am appear with my learned junior Anusha, representing the respondent, the Democratic Republic of Tanve. May it please the Court.
For appellant, please you can.
May it please the Court, with your kind permission, I shall state the brief facts of the case before the Honorable Court. The Democratic Republic of Tanve has enacted the Citizens Data Security and Regulation Act 2024. Section 12 of this law requires every social media company and digital platform to provide the government with a master decryption key. That key allows government agencies to decrypt and monitor all user communications in real time whenever they want. There is no need for the government to get a judge's order, and there are no clear checks on who can use this power, when or why. Connect Private Limited, which is a leading social media company in Tanve, together with digital right activists, are challenging Section 12. They believe that Section 12 violates the fundamental rights of citizens guaranteed under the Constitution, mainly right to privacy, the right to freedom of speech, and the right to due process. The government argues this surveillance is needed for national security and to prevent crime, and that the law is a reasonable restriction allowed by the Constitution. These are the essential facts. May it please the Court. With this summary, I now lay out the main issues for the Court's consideration. The first issue is whether Section 12, which requires a master decryption key for real-time surveillance, violates the fundamental right to privacy. The second issue is whether Section 12 puts a restriction on rights that is disproportional, whether it goes beyond what is needed for national security. The third issue is whether Section 12 is invalid because it has no adequate procedural safeguards and judicial supervision. My lords, I will address the privacy issues and the question of proportionality. After me, my learned junior will complete the remaining arguments on safeguards, international law, and the reliefs we seek. May it please the Court, I begin by addressing the crucial right to privacy. In Justice K.S. Puttaswamy versus Union of India, this Honorable Supreme Court declared that the right to privacy is a fundamental right protected by the Constitution. Article 21 guarantees life and personal liberty, which includes the right to control one's personal information and private communication. Section 12 breaks this protection. Section 12 does not target specific criminals or limited access to suspicious messages. It covers everyone, everywhere, all the time. This means the government has access to every conversation between citizens on social media, business messages, private family chats, personal opinions with no limit. There is no rule requiring a court order or that government officials must explain why they want access. Such absolute power is against the very idea of privacy. It is like giving the government a master key to every house in the country and allowing entry without knocking or asking. The Supreme Court in the Puttaswamy judgment made it clear any violation of privacy must have a strong justification, must follow a clear procedure established by law, and must not be arbitrary or unlimited. Now turning to proportionality, this law is required to find a balance between the rights of citizens and protecting national security. Even if national security is a valid reason, the chosen method should not be the most extreme one possible. Section 12 is a blunt and excessive. It does not distinguish between ordinary citizens and people who are under suspicion. It does not say whose data can be checked, how often, or for how long. Instead, it mandates a master decryption key for every user all the time. This is disproportionate to the legitimate aim of stopping crime or terrorism. The blanket access provided here is excessive, less intrusive. Targeted actions would get the job done without harming the privacy of millions who are innocent. The Supreme Court in Maneka Gandhi versus Union of India has repeatedly guided that all restrictions on rights must be reasonable and not arbitrary or unfair. Freedom of speech is also affected. Citizens must feel safe to express their views, personal or political, without fear that the state is reading every message. Real-time, unchecked surveillance creates fear and discourages people from speaking up or sharing ideas. When citizens believe they are being watched, their freedom of expression gets limited. This is known as the chilling effect. Both Article 19, Clause 1, Subclause A and Article 21 of our Constitution are threatened by Section 12. The government may claim that Section 12 is needed for fighting cybercrime, terrorism, and national threats. However, our argument is that the law provides too much power and too few protections. Surveillance should be used only in exceptional cases with a specific purpose, a court's permission, and regular checks. Section 12 does not do any of this. It skips all procedures and hands over absolute powers to the authorities. This opens the door to misuse and even political harassment. Comparing this to globally accepted standards, most democracies follow strong checks and balances before allowing surveillance. The European Court of Human Rights in the Big Brother Watch Limited versus Union Kingdom case struck down rules similar to Section 12 due to lack of safeguards and unlimited powers. To conclude my submissions, Section 12 violates the right to privacy, is disproportionate, affects freedom of expression, and is not supported by effective safeguards or court supervision. I now respectfully hand over to my learned junior to address the rest of the issues and conclude our side.
Respected applicant, under the Article 19(1)(a, freedom of speech expression, you are claiming that, but by using social media, the many social media groups or anyone propagating false news, false propagations about politicians, about celebrities, about even judges. So why can't we enforce this law?
Respected Your Honor, fake news is spreaded all over the country, it's true. But we need to give access only for the suspicious messages and suspicious videos or anything, sir.
Okay.
But not all the information which is personally which is personally done by the innocent members.
Okay.
And it should not be given to the government. All access should not be given, sir. Complete access should not be given. Only for the suspicious messages should be given.
Okay. What are the guidelines given under the judgment of Puttaswamy case? You have quoted.
Your Honor, under Puttaswamy judgment, it is known as the right to privacy verdict case.
Okay.
Here, right to privacy was protected as a fundamental right under Article 14, 19, 21. These are called as golden triangles of the Constitution. Here, Article 14 states that the state shall not deny any person equality before the law or equal protection before the law. And the Article 19 states that freedom of expression and information should be given to the people. And also the Article 21 protects the right to life and personal liberty. By these three rights, every person should enjoy their freedom equally, sir.
Okay, sir. Any questions?
How do international human rights standards support your claim?
Your Honor, International Human Rights said that under certain acts and under certain sections, they decided that discrimination against phone searches or data extraction without any proper safeguards should not be done, sir.
I think you have mentioned about ICCPR and European rulings, right? I think you can quote that.
Your Honor, Article 17 of ICCPR says no one should be subjected to arbitrary or unlawful interference with their privacy. And also, democracies, including the European Union, require that all surveillance must be necessary, lawfully authorized, and proportionate.
Okay.
Thank you. Thank you, Counsel. We will now hear from the Junior Counsel of Appellant.
May it please the court, My Lord, I am Bolli Vidya, Junior Counsel for the appellants. I shall present the arguments on lack of safeguards in the Act, international principles that support my argument, and the reliefs we seek. My Lord, Section 12 of the Act does not require the government to get permission from a court before carrying out surveillance, nor it provides independent review or periodic inspection by any authority outside the government. There is also no obligation for the government to record, review, or report its surveillance activity. This definitely means that the law is open to misuse or abuse, especially against those people who may not agree with the one in power. The Aadhaar case 2018 judgment rightly emphasized that for any restriction of the right to privacy to be valid, there must be strong safeguards such as judicial review, public transparency, and the citizen rights to challenge and correct government action. Without this law, it fails the basic test of due process and fair treatment. Apart from our constitution, the Democratic Republic of Tanway has ratified global treaties like the International Covenant and Civil and Political Rights. And Article 17 of ICCPR says no one should be subjected to arbitrary or unlawful interference with their privacy. And also, other democracies, including the European Union, require that all the surveillance necessary must be lawfully authorized and proportionate. The United Nations and its Human Rights Committee have published clear guidelines saying must be lawfully authorized and proportionate. The United Nations and its Human Rights Committee have published clear guidelines saying surveillance can be justified only when it is specifically targeted at those reasonably suspected of crime. That too only for limited periods and with the court approval and independent oversight. The case of Big Brother Watch in the European Court of Human Rights makes it clear that mass surveillance powers without safeguards are against human rights. And coming to the relief we seek, we respectfully request the Honorable Court to declare Section 12 of the Citizens' Data Security and Regulations Act 2024 as unconstitutional and invalid, being in violation of Article 14, 19, and 21 of the Constitution. And secondly, we request the court to strike down the requirement that all social media companies must provide a master decryption key. And thirdly, the court deems any form of surveillance to be possible in the future. We pray for a direction that any future law must have clear, strict, and transparent procedures, such as prior judicial approval and periodic review by an independent body. And also, detailed transparency reports must be available to the public. And my Lord, above all, people must have an effective way to challenge unlawful surveillance and get redressed. My Lord, I wish to conclude by emphasizing that surveillance may serve the interests of security, but it must not come at the cost of destroying our rights and freedoms. Section 12 of CDSRA places our entire population under suspicion and removes all limits on the state power. And I believe this is not the vision of justice or fair governance under our Constitution. We respectfully pray to the Honorable Court to set aside Section 12 and declare the privacy and freedom are the cornerstones of a free and democratic society. We further pray for any other relief that the Honorable Court may consider just and proper. Thank you, Your Lord.
Can you suggest alternative methods, safeguard that could make the provision constitutional?
My Lord, actually the already existing laws like prior permission from the court before conducting any surveillance are enough in my opinion.
Respected junior counsel, you have quoted the human rights in Big Brother Watch Limited and UK. There was a case.
Yes.
So what was the guidelines given on this case in Europe? Big Brother Watch Limited versus UK.
Yes.
What are the guidelines? Could you briefly explain?
So, my lord, it was a landmark judgment in the European Court, where the court held that the mass government surveillance of communications without clear limits, independent oversight, or judicial review violated the right to privacy. The main point is that secret blanket data collection is unconstitutional. If it lacks strict safeguards, this directly relates to the present case because Section 12 of the CDSRA allows similar broad unchecked surveillance without proper procedure and protection.
Which article of Constitution of India talks about the freedom of speech and expression?
Freedom of speech and expression. It's Article 19, sir. Sorry.
Article 19 1A. Okay, thank you. Thank you, Counsel. We will now hear from the senior counsel of the respondent.
May it please the court, Your Honor. Your Excellency, the fact scenario presented by appellants are incomplete. The actual facts are cyber-terrorism is anonymous, borderless, instantaneous attacks can shut down power grids, airports, hospitals, and financial systems in seconds. Section 12 is not equal to surveillance state. It is targeted surveillance with safeguards, not blanket spying. National security is greater than fundamental rights of the citizens. Without national security, no rights can be survived. The main objective of this act is to protect citizens' lives and ensuring the national security. The government maintains the provisions is necessary, proportionate, and constitutional, given grave threats of terrorism, cybercrime, and online radicalization. Section 12 requires social media and instant messaging platforms to provide the government with a master decryption key for real-time surveillance. According to harm principle, the state or society may only restrict an individual's liberty to prevent harm to others. Citizens' absolute privacy may enable terrorists to cause harm to society. Therefore, restricting privacy through Section 12 is justified because it prevents greater harm to public at large. Paternalism is when an authority restricts someone's freedom or makes decisions for them, claiming it is for their own good, welfare, or protection. Right to privacy is fundamental right, but not absolute. This is necessary for national security, citing cyber-terrorism and online radicalization incidents. The case has been fast-tracked to the Supreme Court of Tanve due to its immense constitutional importance, balancing right to privacy versus national security. By enabling the real-time surveillance of all user communications, the corruption and crime rate will be reduced in this society. These are the facts, Your Honor.
Okay, you may proceed.
May it please the court, Your Honor. The two issues presenting before the court, I am dealing with the first issue, whether Section 12 of the Citizens Data Security and Regulation Act of 2024 violates the fundamental right to privacy by mandating blanket and indiscriminate surveillance of all citizens. Digital communication. On this issue, my submission is no. It is not violates the fundamental right to privacy of citizens, Your Honor. Section 12 is not blanket spying, but subject to executive approval, judicial review mechanisms, parliamentary oversight, giving it to the force of law rather than arbitrary executive action. Section 12 is a necessary measure designed to address real and imminent threats of terrorism, cyber attacks, and misinformation campaigns. In 2007, cyber attack on Estonia was a large-scale distributed denial of service attack launched late April 2007, targeting the nation's government websites, financial institutes, and media outlets. The Estonia attacks effectively shut down online services, froze ATM machines, and disrupted essential government, financial, and media services. Your Excellency, to strengthen the Tanve's cyber security system, citing cyber-terrorism and online radicalization, this measure is taken by the Democratic Republic of Tanve for national security. Cyber-terrorism is modern times terrorist attacks by hacking government online services and government data. This is the main concern for national security. For this, modern cyber-terrorism, traditional surveillance methods are inadequate. To ensure the national security, the Democratic Republic of Tanwe mandates that all social media companies and instant messaging platforms operating in Tanwe must provide the government with a master decryption key to enable the real-time surveillance of citizens under Section 12.
Does Section 12 distinguish between the targeted and mass surveillance? That's what I'm asking you. Does Section 12, what you mentioned, that is it distinguishing between the targeted surveillance and mass surveillance?
Yes, Your Honor. The Section 12 is enacted when the cyber attacks are concerning the national security have introduced similar measures. Tanwe wants to adopt a comparable approach. National security is greater than the fundamental rights of the citizen. Right to privacy is a fundamental right, but not absolute. In Justice case Puttaswamy versus Union of India case, the judgment established that the right to privacy is a fundamental but not absolute, can only be restricted by law that serves a legitimate state purpose and is proportionate and fair. In Karak Singh versus State of UP 1962, the Supreme Court of India held that a right to privacy was not a guaranteed fundamental right. The government asserts that national security is paramount and safeguarding lives is a constitutional duty of the state. The IT Act 2000 includes provisions and penal provisions to deal with cyber crimes and cyber attacks which can pose a threat to national security. The state's duty to protect life supersedes individual privacy. Protecting citizens from terrorist attacks, cybercrime, and online radicalization is a compelling interest that outweighs individual inconvenience. Without access to encrypted data, the state cannot effectively prevent or respond to cyber threats, which are putting lives at risk. The cyber attacks can shut down power grids, airports, hospitals. The master key is held by the government under strict protocols for not arbitrary use. Internal review mechanisms, cyber security safeguards, and accountability frameworks prevent abuse. Judicial oversight can still be invoked in the case of misuse, but operational secrecy is vital to protect national interest. The Act do not treat citizens as suspects, but it works when an issue arises which concerning the national security. The Act will use the data to face and prevent the issue.
Respected Senior Counsel, you have quoted the case Kartar Singh versus State of Punjab. What are the guidelines given under this case by Supreme Court? Could you briefly explain?
May it please the court, Your Honor. Kartar Singh versus State of Punjab case filed a writ petition in the SC arguing that right to move freely throughout the territory of India, Article 19(1)(d), and right to personal liberty, Article 21, are violated. The SC upheld that the secret surveillance did not restrict physical movement. The majority did not recognize the fundamental right to privacy.
So what the Article 51A of Constitution of India deals with? Article 51A of
fundamental duties.
So what is the responsibility of the government regarding this? Under 51A, what was the duty assigned to the government under Article 51A? You have mentioned here. Look at.
Every citizen has a fundamental right to uphold and protect the sovereignty, unity, and integrity of the nation. If citizens have a duty to protect the nation, the state has a corresponding power to enact measures like surveillance for collective security.
Okay, very good. Okay, Karen, thank you.
Respected Senior Counsel, what procedural checks exist to prevent misuse of this master key?
The judicial oversight can still invoked in the case of misuse. Judicial oversight can still be invoked in the case of misuse, but operational secrecy is vital to protect national interest.
Okay, please proceed.
Thank you, counsel.
The rest, I rest my case. My learned junior shall now expound upon the second issue. May it please the court.
Okay. Thank you, counsel. We will now hear from the junior counsel of the respondent.
May it please the court.
You may proceed.
Your Honor, I appearing as a junior counsel on behalf of respondents and dealing with the second issue, whether the state's interest in national security and public order can justify the imposition of measure that is disproportionate and lacks the necessary procedural safeguards to protect the fundamental rights of individuals. Our submission is that it is not disproportionate. Your Honor, the government maintains that the provision is necessary, proportionate and constitutional given the grave threats of terrorism, cybercrime and online radicalization. Proportionality of the provision, and it must be viewed in the context of security. The doctrine of proportionality must be understood differently when national survival and citizen safety are at stake. Courts have recognized that the state's duty to protect life under Article 21, which is protection of life and personal liberty, can override privacy concerns. For example, it's established in Modern Dental College versus State of Madhya Pradesh 2016. Proportionality requires balancing rights with legitimate aims. Is counter-terrorism, cybercrime, radicalization. Its decryption is essential to trace threats. No less intrusive alternative works against end-to-end encryption, and privacy intrusions are outweighed by the protection of life and security. Your Honor, national security constitutes a compelling state interest. The foremost duty of the state under Article 21 is to protect the lives of its citizens. Cyber-terrorism and radicalization through encrypted platforms have become a global reality. For example, in Delhi riots 2020, that's fake news and communal propaganda spread on WhatsApp and more social media fueled violence. A real-time decryption mechanism could have prevented escalation and restored public order swiftly. Thus, the provision is necessary to combat evolving digital threats where terrorists and criminals hide behind encryption. Duty of the state to protection citizen under Article 21 guarantees not just personal liberty, but also protection of life and safety of all citizens. Section 12 ensures security by preventing large-scale violence and terrorism. This is not violative of Article 21, but furthers it.
Respected counsel, may I interrupt for a while?
Yes.
Audience in this court are making nonsense. Disciplinary action will be taken against the person who are making nonsense. Penal action will be also be taken. Be careful. Thank you for cooperation.
Your Honor.
You may proceed.
Your Honor, in Manka Gandhi versus Union of India case 1978, the court held that restrictions on liberty.
Junior counsel, you may proceed.
Your Honor, in Manka Gandhi versus Union of India case 1978, the court held that restrictions on liberty are valid if they follow due and serve public interest. Your Honor, balance is between individual privacy, Article 21, versus right to life and security of millions. The state argues that where there is a conflict, collective security outweighs individual privacy. The measure may seem broad, but it's the only effective method against encrypted communications where terrorists hide in plain sight. Your Excellency, Section 12 of Act may appear stringent, but in the face of unprecedented cyber threats, the state can't afford half measures. The restrictions, though wide, is justified by compelling national security needs, supported by global democratic practices, and aligned with the principle that fundamental rights are not absolute, but subject to reasonable restrictions in larger public interest. Your Honor, cyber-terrorism poses a direct threat to national security and life. It hackers seize control of Tanway's air traffic control system. The risk of plane collisions and mass casualties become imminent. Such threats are not speculative. For example, in 2018, the UK's Gatwick Airport faced major disruptions due to drone and cyber vulnerabilities. And Information Technology Act 2000 already defines and criminalizes cyber-terrorism and empowers the government to intercept and monitor communication in interest of national security. Comparative jurisprudence and global practices, countries like United States Patriots Act 2001 allowed wide-ranging surveillance to combat terrorism, upheld by court as necessary for national security. And in UK's Investigator of Powers Act 2016 empowers authorities to demand decryption. Australia's Assistance and Access Act 2018 obligates the service providers to facilitate lawful access to encrypted data. In the digital age, global democracies recognize that privacy must bend when national security is at stake. Section 12 is a constitutionally valid, necessary, and proportionate measure to combat digital era terrorism. The right to privacy must yield to overriding public interest of security, and provisions should be upheld. Constitutionally, under Article 19, Clause 2, restrictions on free speech are valid for security of the state, public order, and prevention of offences. Section 12 falls squarely within the scope. Article 21, the right to life and security of millions outweighs the privacy claims of individuals. In People's Union of Civil Liberties versus Union of India addressed the issue of telephone tapping and right to privacy. The court upheld surveillance subject to statutory safeguards. Section 12 provides such a legislative framework ensuring accountability. There are international obligations require strong action, Your Honor. UN Security Council Resolution 1373 in 2011 direct member states to take effective measures against terrorism, including online radicalization. Section 12 aligns India with these obligations, ensuring compliance with global standards. In light of facts and circumstances of the present case, the arguments advanced herein, it's most respectfully prayed before this honorable court that it may be pleased to uphold the constitutionality of Section 12 of Citizens Data and Security Regulation Act 2024 as a valid, reasonable, and proportionate restriction in interest of national security, sovereignty, and public order in accordance with Article 19, Clause 2 and Article 21 of the Constitution of India. Dismiss this petition filed by the petitioners challenging Section 12 of this Act as being devoid of merit. Recognize the state's paramount duty to protect the lives of its citizens from grave threats of terrorism, cybercrime, and online radicalization, which necessitates such statutory powers.
Close your arguments.
Pass any further orders that this honorable court may deem fit in the interest of justice, equity, and good conscience. May it please the court.
One last question. Why should public safety outweigh potential privacy concerns in this case? Why should public safety outweigh potential privacy concerns? You already mentioned, I think two paragraphs before.
Respected Junior Counsel, so what is the aim of IT Act 2000? Could you explain briefly? I think this is more sufficient again doing another law.
Section 43 under IT Act 2000, Section 43 of penalty for unauthorized access, and under Section 43A, compensation for failure to protect sensitive personalized data. Section 66F is a cyber-terrorism.
What the Section 66 of IT Act 2000 talks about? Section 66 of IT Act 2000. Anyone student from Constitution have you heard about Shreya Singhal case? Shreya Singhal case. Okay. Thank you, respected Junior Counsel.
May it please the court.
Thank you, Counsel. The court is now open for rebuttals. Counsels of the appellant, do you have any rebuttals, Counsel?
May it please the court. Your Honor, I would like to counter the arguments of the respondents where they mentioned that surveillance is necessary for national security. Respectfully, national security is important, but unlimited surveillance without safeguards is not justified. Our Constitution requires that any restriction of rights must be reasonable and proportionate. Security can be protected through targeted, court-approved investigation, not mass surveillance of everyone. And they also mentioned about privacy. Privacy has restriction, yes, but reasonable means there must be proper checks, limits, and oversight. Section 12 is not reasonable because it gives blanket access to all data without any court order or review, going far beyond what is necessary. As they mentioned, other countries have surveillance laws. In democracies, even where such laws exist, strong safeguards and court approvals are always required. Where mass surveillance passed without checks, courts struck it down, such as in the Big Brother watch case in Europe. As they also mentioned in Indian Constitution, there is no right to privacy in general. But privacy is a part of liberty which is mentioned under Article 21.
One more question. How this law will affect the common man? How this law affect the common man? You are telling affect the privacy of the people. Could you give some examples?
So would you please give me 2 minutes of time?
Okay, carry. You may proceed.
Guys, those who are making noise at the end or whoever is speaking in the middle, we are having a kind of surveillance state here, which is also the case in discussion. We are having a surveillance on you and we are noting down your names. We already got 2 or 3 names. At the end of the session, we will call your name out and you are supposed to speak. Okay? Already we got 2 names. So beware, your name also might be in the list. If at all you are speaking for the next 20 minutes or so, while the proceedings go on, your penalization will be by asking you to speak on the days. So mind that.
May it please the court?
You
Your
may
Honor, freedom of speech is affected by the freedom of speech of the people is affected. Citizens must feel safe to express their views, personal or political, without fear of the state, fear that the state is reading every message. Real-time and unchecked surveillance creates fear and discourages people from speaking up or sharing ideas. When citizens believe they are being watched, their freedom of expression gets limited.
Okay. Thank you. Thank you, counsel. Counsel of the respondent, do you have any rebuttals? Rebuttals? No? Okay, you may proceed. You may proceed.
They are mentioned that the Section 12 provisions. Section 12 is not blanket spying. It is subjected to executive approval, judicial review mechanisms, parliamentary oversight, giving the force of law rather than arbitrary executive actions. The surveillance state is a nation state that uses widespread monitoring of its citizens and visitors to collect, store, analyze, and distribute information about their actions, locations, and communications. Article 21, Protection of Life and Personal Liberty. In Justice K.S. Puttaswamy versus Union of India, the Supreme Court of India that held that the right to privacy is fundamental right, but subject to reasonable restrictions in the interest of national security, public order, prevention of crime. You may place the court, Your Honor.
You may proceed. Over.
Respected senior counsel, how do other democracies balance digital surveillance with rights protection?
Budapest Convention on Cybercrime 2001 promotes international cooperation in digital surveillance and data access.
Okay, thank you, counsel.
May it please the court, Your Honor.
Okay.
Thank you, participants. You may retake your seats amongst your audience.